And then why does this checklist matter? Who cares? Why are we talking about this today? Well, this is why you should care. Because any director or officer of your organization can sue your organization if they believe that anyone involved in your organization has violated the act. So any officer or board member has the standing to go to court and file a lawsuit to force your corporation to follow the act. The Attorney General, of course, on his or her own, can start an investigation of your organization if he or she is given reason to think that someone in your organization has violated the act. And usually that reason comes from people involved in your organization, whistleblowers who go to the AG and say, hey, look, here's some evidence that this organization is violating the law. And then the AG has a pretty broad authority to investigate your organization. And a result of either a lawsuit or the AG's investigation can be personal fines. And this is new. The current act does not provide for fining people with a civil violation of up to $5,000 per violation of the act. But the new act does contain that. So you as a staff member at an organization, if your organization violates the law, you could be held personally liable for up to $5,000 per violation. That's new. Board members can be sued personally if they breach their fiduciary duties. That's not new. That's always been the case. And of course, your nonprofit corporation can have its charter revoked and just be shut down. So that's why this stuff matters. How often does anyone do this? How often does anyone sue a nonprofit or the AG get involved? Not very often. The chances of this happening to your organization are pretty darn slim. But it could happen, and that's why we're talking about this stuff. And then lastly, any actions that your board takes at a meeting that was not properly called or properly taken in the meeting is void. It's like that action never happened. So if you have bylaws that say that your board members serve 3-year terms and then they're done, and you have board members who've all been there for 5 or 6 or 7 or 10 years without being reelected to a new term, well, legally, they're not board members anymore, and the actions they've been taking for the last 3 years are all void and can all be undone by the Attorney General. So that's why it's important to watch your bylaws, because if you violate those bylaws, then you can go back up to any director or officer who can sue your organization and say, look, they didn't follow their bylaws. All those decisions they made when they weren't following their bylaws are now void, and your organization has to go back and redo all that stuff. Okay, so that's the context. Any questions about any of that stuff? I assume some of you are eating. I hope this is great lunchtime information to have while you're having your lunch. Okay, I'm gonna move on to the checklist. And I'm going to share that with you and just walk through it, which I know kind of sucks because then you're just looking at this piece of paper on your screen. You don't get to see me gesticulating. So, you know, it's not as much fun, but I think it's easier if we all just look at the same piece of paper as I walk through it. So here we go. Okay, hopefully you all see that. I'm just going to go through this. I might go through it fairly quickly, because a lot of this won't apply to most of you, or some of it won't apply probably to any of you. And in particular, please stop me as I'm going if any of these apply to you and you have questions about any of them. So in case you're wondering at the seemingly kind of random order of these items are in this checklist in the order they appear in the act. So I just read through the act and just pulled out stuff in the order that they come up in the act. Does your nonprofit have ex officio members? Ex officio members are people who are on a board or on a board committee because they have some title. So it could be that you have a county commissioner on your board because your bylaws say county commissioner has a seat on our board. Or it could be that you have a member of the school board on your board, or you have someone appointed by the school district. Or say, what's really common is your executive director is a member of your board. That's an ex officio member of the board. The new act states that ex officio members have a right to vote, that they are full-blooded board members who get to vote on everything, which I found a little interesting because often ex officio members don't have a right to vote, especially if it's the executive director of the organization. So if you are an executive director of an organization and you are an ex officio member of your board and your board does not intend for you to have a right to vote, then you need to make sure that your bylaws specifically say now that you do not have a right to vote. Because if your bylaws don't specifically say that, then come January 1st, when this new act goes into effect, you will have a right to vote. So check that. Does your NPO want the act to apply to members? So I'm gonna go sideways here for a minute. Assuming you all didn't have a chance to read this, up above I gave a little explanation of membership corporation versus non-membership. There's often confusion in the nonprofit world about what is a member. Because lots of organizations just call people members who donate money, right? You know, you donate money to the Humane Society and you're a member of the Humane Society or whatever. Typically, those are not members as the law defines them. The law, the current act, allows nonprofit corporations to set up classes of people called members and give those classes of people legal rights within the organization. Typically, those rights are something like elect the directors, maybe approve the annual budget, approve any effort to sell all the assets of the organization, stuff like that. Kind of high-level decisions can be given to this class of people called members. These are governing members of the organization. These are not people who you just call a member because they've given money. So I hope that definition is as clear as I can make it. An interesting thing in the new act is that it defines members. The prior act said members can be anybody you want to make them. Whatever you say they can do, they can do. It's up to you, whatever. You define it however you want. The new act says members are only people who have the right to elect the board or approve certain fundamental transactions of the organization. Fundamental transactions are things like dissolving the corporation, selling all the assets of the corporation, merging the corporation, stuff like that. If you currently have members, a governing class of people in your bylaws that you call members who don't have the right to do any of those things, come January 1st, they will no longer be members. They won't qualify as members. So if you have members, bottom line is there's a whole lot in this act that changes the membership system a bit. And we'll hit it a few times as we go through the checklist. You should sit down with an attorney and take a hard look through your bylaws and your articles in this new act to make sure that your membership system is set up in a way that complies with the act and that works for you. Is your nonprofit a religious organization? If it is, the new act specifically states that you don't really have to follow the whole act. If you have religious doctrine or canon law that, in your opinion, supersedes the act, then you don't have to follow the act. So I thought that was interesting. That's really just straight out of separation of church and state, federal law, but it wasn't stated in the prior act. Do you want to provide oral notice of your board meetings or committee meetings? In the prior act or the current act, that's not actually allowed. The current act requires that you provide some sort of written notice. Well, in the new act, you can just provide oral notice. So if you want to be able to do that, then you need to, or if you don't want to be able to do that, you need your bylaws to say, we do not allow oral notice. Otherwise, oral notice is allowed under the new act. And personally, I would suggest you don't allow for oral notice because you have no way to prove that oral notice was given. So if someone challenges an act of the board because the act was taken at a meeting for which proper notice was not given, if the board only gave that notice orally, the person challenging it can say, no one ever told me, and there's no way to prove that they were told, and that whole meeting can be avoided. Do you want to provide electronic notice of your meetings? In the current act, if you want to just email everyone and say, hey, here's the notice for our meeting next week, you could do that, but technically people had to opt into that. and you had to keep the opt-in on file. I know none of us do that, but technically that was the rule. Now the act switches that, and you can go ahead and just use electronic notice, but you have to allow people to opt out. So if someone wants to opt out of electronic notice, they can email you and say, I don't want to receive electronic notice, that doesn't work for me. And then you have to mail them separate notice or give them oral notice if you allow that. So again, just something to check on your bylaws regarding how you handle electronic notice. Here's a really interesting thing, totally new. Might you ever make substantial changes to your significant programs or activities? The prior act didn't try to regulate your activities or your programs in any way, but the new act does. The new act says, if you take donations from the public and you use any of that money to run your programs or activities, and you change those programs or activities or bring on new ones that are totally different and pay for them using your donated money, then you have to report that to the Secretary of State on your next annual report. So that's interesting. Most of us will probably never substantially change what we're doing, but I would suggest that you put this requirement into your bylaws so that years from now, people in your organization know this requirement exists, so that if they do change their programs, they know what to do. And this requirement comes out of a broader focus of the new act on really policing nonprofits to make sure that we are using donations the way donors want us to use them. This is an example of how the new act is trying to make sure that nonprofits use donations in line with donor intent. Okay, if an emergency happens, there's nothing in the current act about emergencies. The new act has this section that says, hey, if an emergency happens due to a catastrophic event, your board can just suspend its quorum rules and suspend its notice rules. And like 3 of your board members could just hold a meeting and make a bunch of decisions for your organization without even telling the rest of the board they're doing it. That's not quite that straightforward, but it's close. And if you don't want that to be a possibility, then you need to specifically say in your bylaws that during an emergency, your board still has to follow quorum rules or notice rules or whatever pieces of that you still want them to follow. If you don't address that in your bylaws, then if there is a catastrophe, then it'll default to these rules where quorum and notice is waived. Yeah, Karen.
Okay, so just make sure that is brand new. So I don't think any of our bylaws probably have that language. So if you do not modify your bylaws, I want to make sure I have this. And a catastrophe happened, earthquake, whatever. Without that amendment to the bylaws, they could call an emergency meeting. Is that how I'm understanding that?
Yep, that's right. If you don't amend your bylaws, then they can waive quorum and notice and just call an emergency meeting.
Okay.
Oh, I have a question. Does the board get to define what a catastrophic event is?
Yeah.
That's a good question. The act does not define catastrophic event. It is so far undefined. And if you cover it in your bylaws, then sure, define it in your bylaws the way you want to define it. But the act does not define it. Okay. Is your organization a private foundation? Yeah.
Is the AG's office going to issue any regs on these? Do you have a sense?
I don't know. I haven't heard that they are.
Okay.
They haven't issued guidance like that for the current act. So I'd be a little surprised if they issued some kind of comprehensive guidance for this act. And this act doesn't authorize the AG to like issue implementing regulations. So they don't have authority to issue regulations. They could provide some guidance. I guess we'll have to wait and see. Is your MPO a private foundation? I think Brian's still on the call, so there is a foundation on the call. So Brian, I'll just say I found this interesting. As I'm sure you know, as a private foundation, there are a bunch of excise tax rules that apply to your organization that don't apply to all the other nonprofits. Like you have to spend 5% of your assets every year, and you have to pay a 1% of your income as basically a tax to the federal government and some other excise taxes. So the act says, and these excise taxes are set up in federal law as, if you don't do this thing, you private foundation, then we will assess this tax. So the federal law doesn't say you can't do this. It just says, if you do this, we'll assess a tax. But now our state statute next year says, you just have to do this. So those excise tax rules for which you have to pay a tax if you violate them on the federal level, on the state level next year, you just have to do it, period. It's not that you pay a tax if you don't. And if you don't do it, the AG could come in and sue you. Does your nonprofit accept donations from donors with restrictions or in response to solicitations? So this is going back to the focus of the new act on making sure we all respect donor intent. The act is very serious about this. And it goes into some detail. So it's not just someone gives you a gift for a capital campaign. And they say, look, I'm giving you $50,000 to help you build this new center. Like, that's clear. There's a clear restriction on that gift. But this goes way beyond that. The act now says that any money you receive in regards to a solicitation, so you send out your year-end mailing, and your year-end mailing says, hey, this is the programs here at the YMCA that we're gonna help fund with this year-end mailing. Well, now you have to use any money in response to that mailing to fund those very programs you mentioned in that mailing. And if you don't, then you can be subject to all the enforcement that I talked about at the beginning, including $5,000 personal fines for people in the organization who knowingly did not use the money the way it was described in your solicitation. And it even goes into enough detail to say that that applies for a year after your solicitation. So if you send out your year-end mailing, and we always have some folks who just hold on to that thing, like they leave it on their kitchen counter and then they mail in a check 9 months later. You always get those little surprise checks. It still applies. It'll apply for a year after you send that solicitation. So they're very serious about this. So this is a part of the act where you could really use some of your attention to read those parts of the act, read your bylaws or your internal policies, and just make sure you're in compliance with that. Do you maintain your board and board committee meeting minutes permanently? Most of us probably do. I mean, I just always do as a matter of course, but the new act requires you to do that. You must maintain your board and board committee meeting minutes permanently. I ask a few times here, I ask if you have members. This one I'm asking because if you do, then the act has a long list of documents that you are required to make available to members. And it talks about the hours during which you have to make them available. And it talks about whether and how much you can charge for copying those documents for them. It goes into quite a lot of detail. So if you have governing members, you really want to take a hard look at that and make sure you're complying with it. Do you have a system in place? Yeah.
Good question. So if you have a manager or a board retreat where you're doing strategic planning, is that a committee meeting, or do you have to keep that permanently and make that available?
That's not defined. My position on that is, if it is a board retreat, it's not a board meeting as long as they don't make any decisions. So they're just having a retreat, they're just talking about stuff, they're not making any decisions. My position is that's not a board meeting. And to make sure that it's not a board meeting, if the board does feel like they made some decisions or they reached some conclusions at the board retreat, then hold those conclusions and bring them forward to your next board meeting and have the board actually approve them at your next board meeting. So nothing is approved at your retreat, so your retreat does not become a meeting.
Thank you.
This is new too. Do you have a system in place to allow directors to review your documents? I mean, of course, we know directors have a right to review our documents. We just kind of know that, I think, as a matter of course, but this says it specifically. And it's very broad, as I think I quoted it here. Directors have a right to come in and inspect your books, records, and documents, which to me says everything. Directors have a right to come in and inspect every document you have in your organization. And it specifically includes appropriate accounting records, which is a new term not used in the Act before. And the Act requires you to keep, quote, appropriate accounting records. Again, not defined, but it's in there. So make sure you keep some sort of accounting records. Does your MPO have members who you do not want to vote for directors? So the new Act defaults to giving members the right to elect your directors. So if your bylaws are silent on whether your members elect your directors, now in the past, your members would only elect your directors if your bylaws said, our members elect our directors. So your bylaws might just, if you don't want your members currently to elect your directors, your bylaws are probably silent on that. They probably don't say anything about members electing directors. But next year, your members have the right to elect directors unless your bylaws say they do not. So just make sure you have that switch flipped the way you want it in your bylaws.
Well, can I go backwards for a minute? I'm still hung up
Sure.
on the books, records, and documents. So we have posted all our 990s based on our accountant's advice, which I think is fabulous. Our 1023 and our 990s are all up on our website, so available to the public all the time. And we use QuickBooks Online. So I'm trying to think how, and they get monthly financial reports, monthly director's reports, and in their board handbook, they get all the policies and things like that. I'm trying to think what else there might be that, and how we make sure we make it available. I mean, I think this is a big workload. I'm just going to say that. I think this is bigger than people think about. If you really want to make it accessible, that's not going to be easy, especially for smaller nonprofits that don't maybe have regular office hours or have all volunteers, things like that. So I think any advice anybody has would be great, or practices that we hear about would be great to share.
I want to
Yeah.
Cole, can I also ask to add to what Mary said?
Sure.
What about like domestic violence centers where you have client files? Surely the board of directors can't access those, right?
I would hope so. I don't remember if there's language in the Act about confidential files. There might be something in there about that. You'd hope there is, but I'm sorry, I don't remember.
Thank you.
Yeah, and Mary, your point's a good one. I think what you're doing at the community council is plenty. It's fine. That sounds like appropriate accounting records, and you have staff, and board members can come in and probably easily get that stuff. And if you're doing QuickBooks Online, you could even, if you needed to, just give someone access online. But you're right, for smaller organizations that just have no staff, it's all volunteers, a volunteer treasurer maybe isn't up to date on all the accounting stuff, falls a few months behind. Some big brouhaha happens on the board and suddenly directors are demanding documents that no one's updated yet. The organization could get in some trouble for that. Okay, I guess I was on to fiduciary duties. So if you have members, do you want them to have fiduciary duties towards your MPO? In other words, do you want it to be possible for your members to be held liable for misbehaving, or held liable if your organization misbehaves? Now, usually the answer is no. But there are some types of nonprofit corporations that are not usually 501c3s, like homeowners associations or other types of organizations that are nonprofits, where they might want, the answer might be yes. But under the new Act, you cannot do that. You cannot have your members have any fiduciary responsibilities or potential liability at all. So if you have members and your bylaws do attempt to prescribe duties like that to your members, you have to get that stuff out of your bylaws. Again, does your MPO have members? There are now, I think the thickest section in the new Act is all about members and how to manage members and set up members, and it goes on and on. And so really, again, just the bottom line is, if you have members, you need to take a real hard look at that stuff, or have an attorney work with you to take a hard look at that stuff and look at your documents and make sure everything lines up the way it should and that you want. Back to members, I just found this interesting. If you have members, do you require that it takes more than 25% of them to call a special meeting of the members? If your bylaws do require more, that say it takes 40% of the members to call a special meeting, you have to change that, because now the act sets an upper limit on that, a ceiling of 25%. You cannot require more than 25% of your members to have to call a meeting. The floor is the same. The floor is 5%. So you can go as low as allowing 5% of your members to call a special meeting. You can't go lower than that, and now you can't go higher than 25. Is your nonprofit a charitable corporation? So I said at the top of this, I didn't cover it today, but at the top of this document, that the act now differentiates between nonprofit corporations that are not 501(c)s and nonprofit corporations that are 501(c)s. And it refers to the latter as charitable corporations. And if you are a charitable corporation, you now have to have at least 3 board members. Before it was just 1, but now you have to have at least 3. And there's some other provisions in the act that apply a little differently to charitable corporations. But that was, I think, the most meaningful one. The new act actually specifies a term length for directors. It says directors have a 1-year term. So if your bylaws for some reason don't specify a term length for your directors, starting next year, their term length will be 1 year. And if they are not reelected after that 1 year, because you're just not paying attention to your bylaws and you didn't know the new act gave this 1-year term length, then after 1 year, legally, they're no longer on your board, and you might not even have a legally elected board to make decisions. So make sure you take a look at that. Yeah, Karen.
Cool. So question there. So I know a lot of us here in the Valley seem to have boards that are elected to 3-3-year terms or some combination of that sort. So does that mean though, if you're in your 3-year term, your first 3-year term, you have to be reelected annually?
No, your bylaws can override this.
Okay.
So if your bylaws say something different, your bylaws control. But if your bylaws don't say anything about term length, next year it's going to be 1 year.
Okay. But even if you do have these terms, these like 3-3-year terms, I have to go back and think about that with bylaws. I don't think like any of us, if you have 3-3-year terms or 2 3-year terms, do you still have to elect at the end of each term? Because it's a term.
You do, yeah. You have to re-elect people at the end of every term. Or if you don't, if your bylaws say it's a 3-year term, but people are eligible to have 2 or 3 of those terms, and someone goes through 3 years, and then you don't have board minutes that show this person was re-elected, starting in month 1 of year 4, legally, they're no longer a board member. And if you had like half your board in that position, suddenly half your board is no longer a board member, and all the decisions they're making could be voided. So you need to pay attention to that.
So as we talk about elections and members, in a corporation, a nonprofit that doesn't have members, and the board needs to be elected, the directors need to be elected on a regular basis, then who elects them? And I guess this should be covered in the bylaws, right?
Yeah, so, yeah, your bylaws need to specify. And typically, if you don't have members, or if you do have members and they don't elect your board, the board elects itself. So the current board members will elect the new board members. But your bylaws need to say that.
Okay.
Okay, hey, do your bylaws at your organization allow directors to remove another director? Most bylaws do. Most bylaws have a provision that allow a board to remove a director, usually for cause, sometimes with or without cause, usually on a supermajority vote. So like your bylaws might say that the board can remove a director for cause with a 2/3 vote. Typically, or under the current act, the board could do that at a special meeting with no notice. If your bylaws didn't require notice of special meetings, then, or your board or your bylaws just said how it's a 1-day notice to call a special meeting, then you could just do that and have the special meeting and remove a director. Well, now the act specifically says that if your board's going to have a meeting where it wants to consider removing a director, it must give at least 48 hours notice of that meeting. And you can't change that in your bylaws. So I don't think anyone's bylaws are going to have this in there, although some of you might have bylaws that already have a special meeting notice longer than 48 hours, and that's fine. If you already have a notice requirement that's longer than 48, just leave it. But if you don't have a notice requirement in your bylaws for a special meeting, you need to put this 48-hour notice in there for any meeting at which the board wants to consider removing a director. Does your bylaw specify the amount of notice that must be given for special board meeting? Same thing I was just talking about. So it is required, it's a little confusing here. 48 hours notice is required for any special board meeting at which a director might be removed. But 48 hours notice also under the act just becomes the default for any special meeting, regardless of what you're going to consider at the meeting. The default will be a 48 hours notice required under the act, but that can be changed in your bylaws. So if you don't want to have a 48 hours notice for just any old special meeting, you can change that. You don't have to have any notice, which I find strange. Hopefully that wasn't too confusing. Do your bylaws specify who can call a special board meeting? Interestingly, the current act does not have a default provision that specifies who gets to call a special board meeting. So most of us just have a provision in our bylaws that says something like a special board meeting can be called by the president or the vice president or a majority of the board or something like that. Or maybe a lot of us have bylaws that are silent on the issue. Well, if your bylaws are silent on the issue, starting next year, what I wrote here is what will be the case, that a special meeting of your board can be called by the president, secretary, or 20% of the directors. So that's the default starting next year. President, secretary, or 20% of your directors can call a special meeting, unless your bylaws or articles say something different. Do you want to allow minors to serve on your board? I thought this was interesting. I'd never even thought about that before. But like Karen, you might find that interesting at the Y. It wasn't actually legally allowed before, but under this act, it is. It's specifically stated you can have minors on your board, people under the age of 18, but there are just a few rules that apply to them differently. Like a couple I wrote here, they don't count towards your quorum requirements, and there's a percentage limitation. I don't remember what it is, like maybe a third, you can't have more than a third of your board or something like that. Do your bylaws allow for board decisions by unanimous written consent? And what that means is most of our decisions are made at board meetings, and someone makes a motion and someone says, let's vote, and people vote with their mouths at a board meeting. And usually only need a majority of the people in the room to say yes for a thing to pass. Another way for the board to pass resolutions or make decisions is to just sign a piece of paper, and it's called a unanimous written consent. So the board can just sign a consent. And if everyone signs that piece of paper, then whatever the resolution on that paper is approved by the board via unanimous written consent. They don't have to have a board meeting. A thing that most nonprofits do illegally is they go ahead and let their boards make decisions like this, but don't require the decisions to be unanimous. And so the typical way that nonprofits these days do decisions via written consent is over email. So you send an email out to your board and you're like, hey board, I need a decision on this question. Would everyone please email me back and tell me what your decision is? Legally, for that decision to count, to have been made, every single one of your board members has to vote yes on it. It has to be unanimous or it doesn't count. That's still true in the new act. Now, so that first part what I'm saying is kind of just an aside. That's how it is now. It's supposed to be unanimous. Most of us don't really follow that. And the way to kind of manage that now is you send the email to your board, you ask for a vote. When you get a majority of them saying yes, then you have enough confidence as the executive director to know that at your next board meeting, you can ask them to ratify that decision and you know a majority of the board will ratify that decision. So in the interim, you're confident to go ahead and implement the decision, even though it hasn't legally been approved by the board yet. But you know at the next board meeting, a majority will ratify it and it'll be okay. That's kind of how most of us kind of deal with this scenario. The only new thing in the new act is that if you want to do something via unanimous written consent and really have it just be via consent and not ratified at the next board meeting, everyone has to sign that document within 60 days of the first person signing it. It all has to happen within a 60-day window.
So this only applies if you're doing a non-meeting and needing a vote. So, because your bylaws typically will say you have to have a quorum or majority or some specified number. This is only when there's not a physical meeting and you need a vote on a topic.
That's right.
In
Yep.
all cases, you have to have unanimous.
That's right.
Okay, got it.
And that's the way it is now.
What we have done and our bylaws allowed it was that, you know, if a board meeting was held and we didn't have a quorum, that we could then poll the people who weren't there. And usually it's unanimous of those who are attending, but we need 2 or 3 more votes. Is that allowed or not? Because we're not looking, we have nothing in our bylaws about this unanimous written consent.
So let me make sure I understand. So you have a board meeting. Let's say you have 10 board members and your quorum is 50%. So you or maybe, you know, 50% plus 1. So you need,
Yeah, our quorum's 12.
okay, your quorum is 12. And you only got 10 board members in the room. Those 10 all vote to approve something. And then what, like right after the meeting, you poll the rest of the board and get a couple more approvals over email? Is that what you're suggesting?
And it's literally like the consent agenda. If it's something major, we're going to hold it over to the next meeting. But if it's the consent agenda, we'll send it out to them and say, hey, what do you think?
Yeah, that is not legal.
Okay.
So but then the question is, do we care? Right? I mean,
I do.
We're just
So it's
talking
good to know.
But if it's,
Well,
if
we're
it's
just
an
talking about
in-person meeting and she
governance,
has
right?
quorum, you have 12 people and 10 show up, you have quorum. And if your bylaws allow quorum,
I don't have quorum. We have a set number for our quorum. It's 12.
oh, you have to have 12, got it.
Yeah.
Never mind.
yeah, so that's not legal under the current act or the new acts. But what I was going to say is, but if it's something like the consent agenda, you know, you could just kind of like take a wink and a nod at it. Because like, who's going to challenge the consent agenda? Who cares, right? But if it's something that is in any way controversial, either in your organization or in the community, and you take your vote that way and you move forward on that vote, if someone challenged it, would be void. Does your board have board committees? So here's a potential large change. The current act does not specify who can be on your board committees, but the new act does. The new act defines and differentiates between board committees and, quote, advisory committees. For a committee to count as a board committee in the law, it has to be made up only of board members. And it has to be a committee that actually has the authority to make decisions on behalf of the organization. And so the take-home message there is, if you have a board committee now that has authority to make decisions on behalf of the organization, and it has people on it who are not board members, starting January 1st, those people on the committee who are not board members have to leave, because that committee that is making decisions on behalf of your board can only have board members on it. Now, the way around this is to take away the authority of the committee to make decisions and instead frame all of the committee's decisions as recommendations that go to your board, and then have your board approve those recommendations. So if the committee is just making recommendations, then it's fine if you have non-board members on it, and it's not considered a board committee under the law. So it has different rules that apply to it than would apply to a board committee. Is that clear? Any questions about that? Okay, and then the last one here on the list Do you have a conflict of interest policy? I hope you do. All 501c3s are supposed to have one. The IRS requires one. The new act includes within it what's effectively a conflict of interest policy that applies to all organizations. What is in the act can be overridden by your bylaws or articles. But if your bylaws or articles are silent on your conflict of interest policy, then the conflict of interest policy in the act applies to your organization. And why I find that really important is because most of us don't have our conflict of interest policies in our bylaws or articles. We have them in standalone policies. A standalone policy does not override the act. Your conflict of interest policy has to be incorporated into your bylaws to override the conflict of interest policy in the act. So I hope that makes sense. And the conflict of interest policy in the act is pretty standard. I think it's perfectly fine. It's a good one. It provides a safe harbor for the board to make decisions where a board member has a conflict, as long as the conflict is divulged and the person with the conflict doesn't take part in the decision, just kind of the usual stuff. But if you want something different, you need to make sure your conflict of interest policy is incorporated into your bylaws. So those were all of the changes in the act that I thought were worth mentioning.